So my name is Derek Graham. I really appreciate everyone logging on and joining us tonight. Um, I'm an attorney here in Columbus. I also want to say a big thank you to Abby Spear and Anna Jeffries. I know they did a lot of the helped with a lot of getting this put together for individuals to listen to and participate in, and we really appreciate their help on that front. So, like I said, my name is Derek Graham. I'm an attorney, and I've been practicing law for 16 years. The first 5 years, I was happily doing business and litigation and a little bit of estate planning. And then 11 years ago, my wife and I had our first child, and we had a daughter, and she was born with Down syndrome. And so that threw me into the world a world that a lot of you know very well, of having a child with special needs. And I started getting a lot of questions about special needs planning and special needs estate planning. And I had one client in particular who kept threatening to fire me if I didn't figure out more about special needs law. And that was my wife. And I was scared to death that if she realized how easy I was to replace with legal stuff, who knows what else she would have replaced me for. So I made a conscious effort of trying to learn and figure out special needs law and developmental disability law. And now almost all I do is practice as a developmental disability attorney. I represent clients through a lot of estate planning issues. I represent clients through guardianship issues. I also do a lot of work helping clients in areas of advocacy, just understanding the system and pursuing benefits within the system, and helping in any area that I can for clients and families that have loved ones with special needs. So tonight, what we're going to talk about in large part is estate planning and some other areas that come up as part of estate planning, and try to help maybe clear away some of the fog or misunderstandings that sometimes occur. So tonight we're going to talk about special needs planning and special needs estate planning and what's entailed in this type of planning. And I can remember so clearly at the outset when my daughter was born, just trying to figure out what was involved in this. And, my pride and my ego refused to let me, hire another attorney to figure out what all was entailed. So just trying to read the rules and the regulations and understand what I needed from a planning standpoint was overwhelming and caused a lot of frustration at different points. And so tonight we're going to talk about some of the concerns families have. When it comes to estate planning, a lot of you are in a unique position. And it is very sad, but also very true that the current generations are some of the first generations that have to do this type of estate planning, for the simple reason that in past generations, the life expectancy of individuals with developmental disabilities was shorter, and it has gotten a lot longer over the last couple of decades. And so it is true that a lot of individuals with developmental disabilities didn't live as long as they are living today. And so a lot of parents did have the mindset 40, 50 years ago that, we don't have to do specialized estate planning because it's unlikely that our children with developmental disabilities will outlive us. And very sadly, that was often true. A lot of concerns come up with, well, I have multiple children, and so my other children will take care of my child with special needs when I'm gone. And that may be true. That may be part of your overall larger plan, but we certainly want to equip your other children to do that in the easiest way possible for them. And so we've got a lot of concerns here. I'm not going to read them all to you, but it's things that you know of. It's, I'm worried that my child's going to lose benefits, or what's going to happen, or will there be money there to help them? As I said, my daughter with Down syndrome is 11, and one of the hardest things for me is picturing what adult life will be like. And I know that's been true throughout her life, of trying to figure out what's it going to be like for her as an adult, what's it going to look like, and how's it going to go. So why do we encourage estate planning? If you fail to plan, you are planning to fail. Everyone involved in this webinar has an estate plan. You either have the estate plan that you've created for yourself, or you have the estate plan that the government has created for you. The estate plan that the government has created for you says that when you pass away, if you're survived by a spouse, your assets will go to your spouse. If you and your spouse are both deceased, then your assets will go to your children in equal shares. And having assets go to your children in equal shares becomes problematic. That's where special needs planning and stable accounts and other tools are used for benefit preservation. So we want to make sure that we take steps so that your plan protects assets, so that when you pass away, assets can go to your children in a structured and safe way. And so we're going to talk a lot tonight about trusts, and we're going to talk about different types of trust. And I want to assure you that the concept of a trust is not nearly as complicated as what a lot of people make it out to be. Every time I say the word trust, I just want you to picture a basket. When you sign a trust agreement, you sign this 30 or 20 or 30-page document full of legal jargon. All you're really doing is creating a basket. And then at some point in time, you're going to put assets in that basket. And there's a number of different types of baskets out there, but ultimately, to create a trust means you're just creating a basket, and then at a certain point in time, you're going to put money or house or personal possessions or whatever you want into that basket. So a little bit more about a trust. So we've got that basket, and then this diagram here. So here's our basket. And so at a certain point in time, assets, we've got keys in here. It could be keys to a car, keys to a house, keys to money, keys to a treasure chest, whatever it might be. Your assets go into this basket. The trust maker is just what it sounds like. It's the person who's creating the trust. The trustee is the person who's responsible for managing the assets in the trust. It may be that the trust maker, the person who makes the trust, and the trustee are the same person for a long time. And then it may be when the trust maker dies, that's when the trustee becomes someone different. And the beneficiary is the person who's entitled to receive the funds or the distributions out of the trust. Now, why are we doing all this special planning? Early on in my daughter's life anyway, I was given literature on Medicaid and Medicaid waivers. And I remember at the time, even in her first couple of years, we spent a lot of time in the hospital. And I remember even at one of our hospital visits, reading literature about Medicaid, thinking, why in the world do I care about Medicaid? My wife, she works at Honda. We have good health insurance. Why do I care about Medicaid? We've got good coverage. Fast forward, and I now realize that the Medicaid is incredibly important for a lot of reasons that in large part have nothing to do with payment of health care, although that's certainly a component of it. Medicaid, as we'll talk about in a little bit, is one of the big tickets to independence and to independent living for my daughter and for your children when they become adults. And more importantly, in the DD system, not to overwhelm you with acronyms, but I think you'll all know that one. The DD system is just developmental disability system. We hear a lot about Medicaid waivers, and they're talked about sometimes with reverence, sometimes with disdain, but everybody knows that they want to get that Medicaid waiver. And so let's talk about what a Medicaid waiver is real quick so that it puts into context why we have to do a certain type of planning for estate planning. Medicaid started back in the 1960s. And the reason Medicaid started, and I'm kind of a history buff, but I'm not going to spend much time on history. It started back in the 60s. And the reason it started was actually very offensive. It started for the simple purpose of Medicaid was the federal government's way of helping states absorb the cost associated with institutionalizing aged, blind, and disabled individuals. And so the states at that time had some of the horrible institution situations in place. That was expensive. And so Medicaid started as a way for the federal government to help with some of that cost. As the federal government got involved, it led to more oversight. And as it led to more oversight, that's ultimately one of the big reasons a lot of those institutions started to close, because we had federal oversight regulators coming in to look at them. Well, it's expensive to pay for the 24-hour care of an individual, and Medicaid under the federal statute was exclusively to be used for the 24/7 care of individuals who were aged, blind, or disabled. Fast forward to the 80s and the 90s, and that by that point, a lot of the institutions, not all, but a lot of the institutions had closed down. And the federal government was starting to realize, along with the states, it's expensive to pay for the 24-hour care of individuals. Wouldn't it be a lot cheaper if we used some of this money to enable these individuals to live in the community with their families or to live in other settings so that we don't have to pay for the 24/7 care? Several statute changes and law changes later, that led to the creation of Medicaid waivers. And so still to this day, when you hear the term Medicaid waiver, you're saying you have an individual that's eligible for Medicaid. Without assistance, they're an individual that could be subjected or could be in need of 24/7 care or assistance with all their activities And because of that, we're going to give them a waiver. And what's being waived is the requirement that they live in a 24/7 facility. And a lot of people don't realize that, but that is ultimately what a waiver is. It's a funding stream created by federal statute where you're saying, we're going to waive the requirement that you live in a facility as long as you're using, and we're going to give you this money as long as you're using it to help in furtherance of you being independent, of you living out in the community. And so Ohio has a variety of different types of Medicaid waivers, and those Medicaid waivers can be used in large part to help further the independence of individuals. In the DD system, the waivers you hear about are the level 1 waiver, the self waiver, and the IO waiver. All are very unique in certain ways, and all are similar in certain ways. Maintaining and preserving eligibility for that waiver, though, is critical because, as a lot of you probably know, and what we have on this slide here is Medicaid is a means-tested resort, or means-tested benefit, which means that you have to qualify. You can't have assets of more than $2,000. You can't have income of more than, and there's a variety of different factors and extenuating circumstances, but in general, you can't have income of more than $2,313 a month to be eligible for that. We also, a lot of your loved ones are probably receiving SSI, supplemental security income, which is one of the many Social Security benefits, and we'll talk about some of the others later on. SSI is also a means-tested benefit, meaning if you have too much in assets or too much in income, it's going to interfere with your eligibility for this benefit. So how does all this tie into estate planning? Well, here in a second, we're going to talk about these different types of trusts. But before we do that, I'm going to go off on one of my little tangents. One of my clients and one of the agencies I've represented for several years now is an agency known as Advocacy and Protective Services, Inc. It goes by the acronym of APSI. And APSI is one of those agencies. I'm obviously a big fan of APSI. I represent APSI, but as a parent, I would never, ever want my child to need APSI, because what APSI does is they serve as guardian of last resort for adults with developmental disabilities. And so if you have an adult with a developmental disability and there's no one else around who can serve as guardian, then APSI will often step in and serve as guardian of that individual. Well, they're guardian statewide for about 4,000 individuals. And one of the things I see on a regular basis is moms or dads who were very well intended and had nothing but the best of intentions for their child with a developmental disability, keep that child at home to protect them and to care for them. And they don't map out what's going to happen when mom and dad pass away. And by not mapping out what's going to happen when mom and dad pass away, when mom and dad do pass away, it leaves all those decisions to the siblings, or if there are no siblings, to SSAs, which is an acronym for Service and Support Administrator, which is your county board, and to other people to step in and fill those gaps and do a lot of that advocacy and help make decisions. And that puts people in a tough position. And so I've seen that countless times in my career. And that's what leads me to say, I think one of the biggest mistakes parents can make is to not have a detailed plan in place for what's going to happen with their child or their loved one when they pass away. And that's not to say your child can't live with you when they're an adult, but that is to say that if they are living with you as an adult, what is the plan? Where are they going to be living on the night you pass away? Where are they going to be living after you're gone? All that needs to be thought out, planned out in detail. As a parent, I know that there's nobody who's going to be a better advocate of your child than you are, and that often applies to siblings a lot of times as well. So you want to take the steps to map that out while you're here to do so. For my daughter, I've always said, when she gets to be, an adult, and I'm picturing in that 20 to 25 age range, I absolutely want her to move out. I want her to live independently, and I want my wife and I to be here to advocate and to find the best roommate and the best setting, and to work with our county board and find a situation that she can thrive in. And I say that realizing that there are a lot of situations out there that you don't want your child to live in, but there are a lot of them that you do. And so I want to be here to be the advocate. I want to be here so that I'm a part and a big part of all those decisions, so that when I do pass away, it doesn't mess that up. And part of not messing that up is making sure that when I pass away, all the assets I want my daughter to inherit are protected. So talking about trust, if you have a child with special needs or a child with a developmental disability, when you pass away, you need to have a trust. For families that don't have a loved one with special needs, they come in and we go over the different types of estate plans, and you can choose this or you can choose that. For individuals that have loved ones with special needs, it kind of makes that part easier because there's really only one good type of plan that you should have. And that plan includes having a discretionary trust, a wholly discretionary trust. And so I've got 4 types of trusts set out here: the discretionary trust, special needs trust, pooled trust, and a supplemental services trust. Now, one of the things you're going to notice is in Ohio, there's a big difference between first-party money and third-party money. And let me explain what I mean by that. Sticking with myself as an example, my daughter's name is Megan. Money that belongs to Megan because she's earned it in employment, or she's in a car accident and we have to sue somebody and she wins $50,000 in a lawsuit. That money belongs to Megan. That's first-party money. As a parent, what I want to leave Megan as inheritance is third-party money. And our system makes a big distinction between first-party money and third-party money. Okay, so when we plan, if we're planning in advance, we're planning for how Megan's going to own and possess third-party money when I'm gone. If we don't do the right planning, Megan inherits the money, and now it's first-party money. And the big difference, one of the big differences, is with this discretionary trust, which again, just picture a basket. As money funnels into that basket, that's a third-party discretionary trust that's created by my wife and I, because we're the ones that created it. It's our money that goes into it. For this discretionary trust, anyone, let's talk about the discretionary trust, anyone in America can put money in my daughter's third-party discretionary trust except Megan. So if grandma or grandpa, if they want to leave money to Megan, and I've encouraged them to do so, even though I think it falls on deaf ears, if they want to leave money to Megan, then by all means do that, but leave it to her through her discretionary trust. And so if Uncle Stephen, Uncle Brian, any of those people want to leave money to their favorite niece, they can, but I encourage them to do so through this third-party discretionary trust. Primarily, though, this trust is going to hold those assets that my wife and I leave behind for Megan when we're both deceased. We're not going to put anything in it now other than a minimal amount, which is $10, but we're going to create this trust and we're going to create this basket. Money that belongs to Megan can't go into it. Money that belongs to anyone else can. One of the nice things about this type of trust is when Megan passes away, whatever money is left in this trust will go wherever we direct it to go upon creating the trust. So in my case, if Megan passes away and there's still money in her discretionary trust, that money is going to go to her other 2 sisters, Ruby and Leah. And it's going to go to them through a different type of trust they have. So in other words, Megan passes away, there's money left. It's going to be used to pay for any funeral expenses, anything like that after she passes away. Everything left then goes off to her sisters. Likewise, though, if one of her sisters dies and they don't have children, then when they die, their money would go to the other children without special needs, and then half of it would come over to Megan in her discretionary trust. Now, contrast that, well, before we go on, one of the very important things about a discretionary trust is it is in fact a discretionary trust. And when we talk about discretion, we're saying there, I just had a question that says, will this document you are showing be available to have? And the answer to that is yes. And I say yes tentatively because I'm pretty sure we have everyone's contact information since you registered for this, but to the extent we do, then we can make this available so you can have it. So looking at the discretionary trust, when we say discretionary, all the discretion is in the hands of the trustee. In this trust, you create the basket. You can say who the beneficiary is. So the only beneficiary of my basket is Megan, and I can pick the trustee. So as long as my wife and I are alive, we're the trustee. When we're both gone, Aunt Julie becomes the trustee. But Aunt Julie has complete discretion. So this trust doesn't say, all right, Aunt Julie, we want you to pay for these things. We want you to not pay for these other things. Here's how we want it to look. For my other 2 daughters, Ruby and Leah, the trust, their trust, which is a separate trust, is all kinds of things. It says, you know, help take care of any health needs, educational needs. When they turn 18, you can use it to pay for college, and otherwise they can have money when they're 25 and 30 and 35 or whatever ages we say. And if they get married, pay for the wedding, as long as the guy's not a jerk, and then don't pay for the wedding. We can spell all of that out in the trust. For Megan's trust, none of that's in there. It just says, here's the trust. It can only be used for Megan, and otherwise we're not giving you any guidance. I can't explain why this is the rule, but the rule is, if that trust said, trustee, I want you to buy Megan Dairy Queen every Friday night. She really likes Dairy Queen, so I want you to take Megan to Dairy Queen every single Friday night and buy her ice cream. That could potentially mess up the whole thing. And that's because we're putting a standard in there that requires a distribution from the trust. We can't do that. And so that leaves people kind of scratching their heads about, well, boy, that's a lot of responsibility to put on the trustee. And think about it if you were someone's trustee. If I woke up tomorrow and I found out, that my brother and his wife passed away, and I now have 2 new kids that are currently my niece and nephew that are now going to be moving in with me, and we're going to be taking care of them. And I have a trust. I have this basket of money that I'm managing for them, and I have no guidance whatsoever on how their parents want me to spend it. That's kind of alarming. So part of what we do to complement this discretionary trust is we have clients complete a roadmap. Part of the roadmap is covering that plan we talked about, where we know where your loved ones are going to live when you're no longer here. But the other part of that roadmap is, let's give some guidance on how you want this money spent, or how you want the money not spent. I find a lot of parents know of things they don't want the money spent on just as quickly as they know of things they do want the money spent on. Now, that roadmap is not binding. If it were binding, it would mess everything up. It's nothing more than a really fancy suggestion, but it's your way as the parent of saying, okay, trustee, I've given you a big responsibility. You're managing all this money for Megan. Here's some guidelines on what I suggest you do with that money. And these are some things I'd really like to see that money used on, and these are some things I wouldn't want to see that money used for. So it gives you the ability to control a little bit from beyond the grave and have a say in how that money is going to be spent. Any questions about the discretionary trust? Okay. So the discretionary trust, then, in summary, is really, in my opinion, the best and the only really good way to leave money to an individual with developmental disabilities right now, because you can leave money to them as much as you want. You could have $10 in this trust or $10 million in this trust, and it's not going to disqualify them from any government benefits, and that's both Medicaid and SSI. Now, when we create these trusts, what we do is we have clients put $10 in it, and putting $10 in it causes the trust to be considered funded. And now that it's a funded trust, if your loved one has a waiver, then we go ahead and send it to your county Jobs and Family Services, so we get that review process taken care of, so that they know that the trust has been disclosed and is taken care of. Couple questions on the discretionary trust, and very good questions. The first question is, what is the poison pill provision? Great question. This trust has what's called a poison pill. Reason being, the law used to be, back in the 90s, that any trust that was for the benefit of someone with special needs automatically disqualified them from Medicaid and SSI. And then back in, I think it was 1994, an attorney in Colorado picked a fight with the government where they created a version of a discretionary trust. And they had a clause in that trust that said, if the government ever counts this trust as a countable resource, then I direct that all the money in this trust be immediately distributed to someone other than the beneficiary. And in that case, it was like Uncle Joe or something. Well, the mom passed away, and the county in Colorado counted it as a countable resource, and it worked its way up and down the court system. And the Supreme Court of Colorado said, wait a minute, you can't count that as a resource because of the discretionary standard in distributing money. But more importantly, if you do, that poison pill is enforceable. And so that poison pill is a clause in the trust that says, if the county or if the state or if the federal government ever say this money is counts towards eligibility for government benefits, then I want basically I want the trust to blow up and all the money to be used by the trustee to take it out of trust and use it in a different way that benefits the individual receiving the services. Another question that was asked, which is a very good question, is, will any taxes be owed when funds are withdrawn? And that's a little bit of a trick question. So when we talk about estate tax, so when mom and dad pass away, when my wife and I pass away, and our money, whatever portion we want our daughter to have, it goes into her discretionary trust. At that point, there's no tax paid on that transaction. So there's no estate tax owed as a result of my wife and I passing away. Once the money is in the trust, and just to use round numbers, let's say there's $300,000 in that trust. I would certainly want Aunt Julie, the trustee, to go to a financial advisor and invest that money or do something with that money. And when she does that, then let's say the money starts earning growth or earning returns on the investment. At that point, someone has to pay tax on that growth. And so if the income or growth is distributed out of the trust to Megan, then Megan is going to pay any tax on that income or growth, which Megan's effective tax rate right now, 0 for the foreseeable future, is going to be pretty close to 0. So it's not going to be a hefty tax bill. In fact, it's going to be a lot less than what I think I would pay on that same growth if I were here. If that income stays in the trust and is not distributed out, then the trust has to pay tax on that income. No different than if any of you have $50,000 and you invest it and it grows by 8%, you have to pay tax on that 8% growth. That's why you get those 1099s and all that stuff in January and February every year. So that there's no special tax owed. It's just that any growth or income is going to be taxed just like it would be if you were still here. Very good question. Now, so that's that third-party trust. Now, people always hear the term special needs trust. And you notice in the slide, I even have in there, it says discretionary special needs trust. I don't like the way a lot of attorneys use the term special needs trust. And so in our practice, we call it a third-party established discretionary trust for the benefit of, being Megan Graham. So we don't use that term special needs trust in the title anywhere of our trust. And that's because, again, all the different agencies that might be looking at this trust, they know there's a big difference between a first-party trust and a third-party trust. A special needs trust is a first-party trust. It's not a tool that's designed to hold assets that belong to mom or dad. A special needs trust, and I see right now there's a typo on this. This says third party. That's what I get for trying to do this quickly. It should be first party. Well, it says third party or beneficiary, but really a third party would never want to put money in this trust. I guess it's on there like that because a third party could, but that'd be a mistake. Because any funds that are in a special needs trust are viewed by the state of Ohio as being first party funds. The only people who can create a special needs trust are the individual, assuming they're not under guardianship, their parent, grandparent, legal guardian, or court. So why would you need a special needs trust? Well, if I pass away and I've done no estate planning, then Megan, by operation of law, if my wife and I are both gone, she would inherit 1/3 of what I own. Well, the minute we pass away, that money from a legal standpoint belongs to her, and her 1/3 cannot then be put into that third-party trust because the money belongs to her. And so she would have to put that money into this first-party special needs trust. Likewise, it comes up a lot with Social Security. Maybe your Social Security benefit changes from SSI to SSD. Maybe some of you have been through that. And you apply for SSD, and it takes them forever and a day to process your application so that when you finally get approved for benefits, you've got a check of $30,000 or $40,000 in back benefits because they pay back to the date of eligibility. Or you could have a situation where you're involved in a lawsuit. Your loved one is hurt in a car accident, so they sue the other driver. The other guy was drunk, and they win $100,000 in a lawsuit. Well, that money belongs to them. So it's got to go into a first-party special needs trust. The biggest difference is at the beneficiary's death, the state of Ohio is going to reimburse themselves. It's going to require you to reimburse them for whatever money they have paid on behalf of the individual. The state of Ohio, if your loved one is on Medicaid, they can tell you to the penny how much they have spent on Medicaid on behalf of your loved one. And so we want to make sure that you understand that when you have this type of trust, if your individual or your loved one is using Medicaid, the state is tracking that. And when they pass away, the state's going to say, now pay us back for what we've paid on your behalf. For that reason alone, you certainly wouldn't want to put mom or dad's money in this type of trust, because I could put money in the discretionary trust for Megan, knowing that when Megan dies, it goes to her sisters. If money's in this type of trust when Megan dies, it's going to go back to the state of Ohio. And that bothers me, because I'd much rather it go to her other sisters. This type of trust, as we'll talk about in a few minutes, with the creation of stable accounts or able accounts, they're not nearly as popular as they used to be, but they're still a very valuable tool when you have an individual who has a lot of money in their name and we have to try to get them back to being eligible. So again, if Megan inherits $100,000 from me and I didn't do any estate planning, then she's going to be ineligible for benefits, and they're going to tell her, you've got to figure something out with that money pretty quick if you want these benefits turned back on. And that's when she could put it into a first party special needs trust. Okay. So got another question here. I have a question about tax ID numbers for the discretionary trust. And so for either of these types of trusts, the discretionary trust or the special needs trust, whether it's the first party or the third party, both of these types of trusts are going to have to get their own what's called tax ID number. And tax ID number, to simplify it, just means you're going to have to get a social security number for the trust, because the trust is its own tax entity. And just to clarify, because there's a follow-up question, when you take money out of the trust, you would only pay tax on it if what you took out was the growth or the income. So if I left Megan $100,000 in her discretionary trust, and a month after I die, they want to spend $20,000 of that on fixing up a house or somewhere for her to live in, they could do that. The discretionary trust could make that payment, and there's not going to be any tax owed on that $20,000, because that's not growth, that's principal. There's no tax paid on the principal when it's taken out of that trust. Okay, so special needs trust, it's a great tool, but it's not part of your estate plan. It's something you're going to use if you have a situation that comes up where the individual has funds in their name. And a lot of times that means there's been a mistake, because there's been unintended inheritance or something like that. You'll hear about a pooled trust. And Ohio has a couple of different nonprofits that provide the services in the arena of pooled trust. The biggest in Ohio is Community Fund Management Foundation. There's also the Dayton Foundation. Both do a good job of providing pooled trust services. When you do a pooled trust, it could be of two different varieties. You could do a pooled trust that is a third-party pooled trust or a first-party pooled trust. And if it's a first-party pooled trust, when the beneficiary dies, whatever's left is going to go to a charity. And you could designate the charity, or if you don't designate a charity, then it will be designated for you. So a first-party pooled trust. So if it's money that belongs to Megan and we put it in a pooled trust, then when she dies, I'm not going to direct where that money goes. For a third-party pooled trust, you can create a third-party discretionary trust with these pooled trust companies, where you do have some control over where the money goes after Megan's gone. Because just like the discretionary trust we talked about, you have some control over where those funds go after your death. Pooled trusts are primarily used in situations where the family doesn't have anyone to serve as trustee. My personal preference is, if you have loved ones or family members that are identified or that you know will do a good job serving as trustee, that is my preference. But these organizations, they do a good job when in those situations where you don't have anyone you can identify as trustee. You know that they'll manage the funds in a way that aren't going to disqualify them from benefits and will certainly preserve the principal in an effective way. The last one I'm only going to spend a quick second on, and that's because it's going the way of the dinosaur and then it's becoming extinct, and that is a supplemental services trust. These were significantly more popular back in the late 90s and early 2000s, before we really had full recognition of wholly discretionary trust, or that third-party discretionary trust. Supplemental services trust, again, it's a third-party type trust, but at the beneficiary's death, 50% of what's left in it has to go back to the state. And so again, this used to be a good option when we didn't have that discretionary trust that I talked about first. Now that we have that, I'm not sure why you would put it in a supplemental services trust knowing that 50% is going to go back to the state when you pass away. So we very, very rarely see these anymore. So determining what trust is right and what you should have or what you should not have, a lot of that hinges on what's the source of the funds, where's the money coming from, and how's the money intended to be used, and how is it going to be used. If it's a third party, then we're going to use the discretionary trust. If it's first party, we're going to use a special needs trust. Any questions on this portion? Okay. What else is part of your plan? So when we talk about an estate plan, it's going to have in it a lot more than a discretionary trust. I should say it should have in it a lot more than the discretionary trust. That's the vehicle that's going to hold money and take care of money for Megan's benefit. There's a lot more that goes into the plan. My wife and I each have a last will and testament. Every estate plan I do here has a last will and testament. I hope it's never used because contrary to popular belief, the only place in America where they really care about your will is in the probate court. And part of the estate plan that we try to create for individuals is to avoid court. We want to try to make sure, you know, when I pass away, I don't want my assets to go through my will. I don't want them to go through a court process. In Licking County, you have a very good probate judge, Judge Hoover. He does a good job, but with, you know, not meant as a criticism to him, I don't want any of your assets to go through his courthouse. And he would tell you that you shouldn't want them to either. And that's because it's public. It takes a lot of time and it complicates things when you pass away. And so you're going to have a last will and testament, but we hope you're never going to use it. If it is used, the last will and testament is what's called a pour-over will, meaning it's going to say, whatever I own doesn't go to my kids, it goes to this trust or that trust. And so in my case, it would say for Ruby and Leah, my younger two daughters, it goes into their portion goes over here into their trust. And for Megan, my daughter with Down syndrome, her portion goes over here into her wholly discretionary trust. You would have a contingent assignment, which is just a document we use to try to make sure your assets, your personal property is not going to go through court. Again, we're trying to make sure on your death, assets are not going to go through a court process. Something called a transfer on death affidavit that's used for real estate to try to make sure that when you pass away, your house doesn't go through court. Your house is, for a lot of individuals, is titled in their name. If you're married, then hopefully it's titled in your and your wife's name, and it's what's called joint with rights of survivorship. If it is, that means when one spouse dies, the other spouse owns it, and you've done a good job of avoiding probate. But this transfer on death affidavit is how we make sure it's not going to go through probate when both of you pass away. So the transfer on death affidavit just says, if I still own this house when I die, I transfer ownership to my kids or my trust or wherever I want ownership to go. But it directs where it goes, so I know it's not going directly into the name of the individual receiving government benefits, and I know it's not going through a court process. Beneficiary forms are critical. Life insurance, retirement, you know, we always work through those and make sure those are filled out and they're filled out correctly so that when you pass away, assets that are going pursuant to beneficiary forms, which again, we hope is the bulk of your assets, we try to make sure nothing's going to go through that court process. Burial plan, that's important. It may just be as simple as writing down, hey, there's plenty of money here to pay for my burial, but here's what I want. If you're married and you pass away, everybody looks to your spouse to make those decisions. If you're not married, or if both of you pass away, then everybody's going to look to your kids to make those decisions. Do they know what you want? Do you know what your spouse wants? I do a lot of work. I work part-time as a contractor for the Ohio Supreme Court, and I was teaching a class one time up in Cleveland for a bunch of judges and magistrates. And one of the judges was giving me a hard time about how, most spouses don't even know exactly what their spouse wants in terms of burial or cremation. And he asked me, he said, "Derek, do you even know what your wife wants?" And I said, "Well, of course I do. She, I know what she wants. She wants to be buried." That next day I was driving home and I was talking to my wife on the phone. I said, "Hey, by the way, you did want to be buried, right?" And she said, "No, Derek, we talked about this. I want to be cremated." And I thought, "Oh, crap." Well, that reinforces why you've got to write this stuff down. You need to know what people want, because you think about these, they're not always pleasant conversations to have, but you do need to have an intentional conversation where you talk this stuff through and you understand what they want. Part of the plan is also the roadmap. The roadmap is filling in all the details. You've got the roadmap for your loved ones, which is critical. What do they need? What do people need to know about them to make that transition as smooth as it can be? So in my case, the roadmap for Megan, that's a Word document we give to clients, and we say update it at least once a year, so that if you die this year, what do people need to know about that transition for your loved one? What's going to make that incredibly difficult transition a little bit easier? And that's information that that other people might not. My daughter has seen a countless number of specialists for a variety of different reasons. And Aunt Julie, while she knows at a high level that her niece has health issues going on, she doesn't know the details. She doesn't know all the in the weeds information. And so that's our chance to write that down periodically, so that if we're gone, that incredibly important information is memorialized. And something else that we offer and encourage clients to do is we have clients make what we just call it a legacy video, which is just, it's nothing you can't do with an iPhone, but we encourage clients as part of the process when they come in at the very end to make a video. So there's a video there, and it's not a sappy, sad, I'm sorry I died video, but just a happy thought or a happy memory, something short that they would have that we put on a flash drive so they would see it when you're gone. If you knew you were going to pass away, or at least if I knew I was going to pass away, when I wasn't hugging my kids, I'd be making videos and leaving notes and all that stuff. And so I like the thought that my wife and I have made a video so that if we do have something horrible happen and we're in a car accident or something like that, I know that at least that one video exists, and I think my kids will get a lot of comfort out of it. In my practice, we started doing that because one of my business partners, he did lose both of his parents at a relatively young age, and his dad knew he was going to pass away and left a bunch of cassette tapes for my partner and his brothers. And he's talked a lot about how much those have meant to him over the years. And that's part of why we wanted to make sure we offered this to clients. So we do have that way for parents to leave something behind about them as part of the plan. And it also gives you the chance to just kind of tie everything together and make sure that, we've thought through what people need to know and leave behind something extra special for them when you pass away. Now, part of the estate plan, though, is also talking about your lives. And this is these are documents over here that every adult who's 18 years old or older, who is able to sign and who has the capacity to sign, should have in place. The general power of attorney is just a document that says, if you can't manage your financial affairs, who do you want managing them for you? The healthcare power of attorney, same thing, just what it sounds like. If you can't make your healthcare decisions, who do you want making those healthcare decisions for you? There's a plan for all of this. And the plan for these situations is, if you can't make decisions, you can go to court. If I have a stroke and I'm not able to make decisions and I'm not able to sign my tax return, the plan that the government has put in place is that my wife can go to probate court, have me declared incompetent, become my guardian, and then she can sign those documents on my behalf. I don't want her to have to do that. By signing a general durable power of attorney, she shouldn't ever have to do that. She can sign my name on the tax return. She can manage the finances, sell the house, whatever she needs to do is not impacted by what happens to me. Likewise, healthcare power of attorney. If I can't make my healthcare decisions, my wife can make those for me. Living will is the document not to be confused with the last will and testament. It just says if I'm terminally ill or permanently unconscious as determined by 2 different physicians, that I would want them to turn off the machines and let me pass. I would say 60% of clients sign a living will and 40% don't. Those that don't say, I don't trust 2 physicians I've never met to make that decision. My spouse or my loved ones know what I want. I'd rather them make that decision. I signed a living will. I love my wife. We have a wonderful marriage. I don't trust her for 1 second to turn off the machines when I would want her to. She's the eternal optimist that would be bringing potted plants to the hospital and moving in with me, and I would much rather them just turn me off and let me go. So that's why I signed a living will, but that's a personal decision everyone makes for themselves. And then also a HIPAA waiver. As you do get older, do you have loved ones that might need to be involved in helping you make decisions? And that's where that HIPAA waiver comes into play. They can get past some of the barriers that prevent them from getting access to medical information about you. The roadmap, a little bit more. We're trying to map out all the extra stuff. And one of the big challenges is the digital age. It used to be 20 years ago when people passed away, you could read their mail for a month and you knew everything about them. Now, for a lot of you watching this, I'm guessing if you passed away, I could read your mail for a year and I wouldn't know everything I needed to know about your finances. Or I might not know who does or who your homeowner's insurance agent is or who prepares your tax return. I mean, that's information that people need to know. And it has become a real burden in the last decade to get the right information. And it is especially difficult when younger individuals pass. When people hire our firm after younger individuals pass away, it has become very cumbersome to kind of figure out where their stuff is. What did they own? What did they not own? And so part of the process is just trying to get all that in a central location. And part of your process should be having all that information in a centralized location so that we can make sure all that money you want to go into that discretionary trust does. Any questions about that? Okay. Stable accounts. A lot of you have probably heard about stable accounts. Some of you probably have stable accounts. The ABLE Act passed several years ago at the federal level, and then Ohio, at the federal level, the ABLE Act said states are allowed to create accounts which are first-party accounts that individuals can put money in, and putting money in these accounts, any money in those accounts will not disqualify them from Medicaid or SSI or other government benefits, which is great. That's what we want. We want more options and places to put money so we don't lose eligibility for government benefits. Now we know that if we have that $2,000 asset limit, well, if someone's working and their account creeps up to $2,400, what do we do? Well, we just transfer $500 to the stable account, and now we're back below $2,000. It used to be at the end of every month, individuals would have to spend the money down. And one of my pet peeves is that because individuals had to stay below $2,000, and they would creep up over it every month or every 2 or 3 months, they would get up above $2,000, and they would truly just have providers that would take them to Best Buy or take them to the mall or take them other places where they would have to find ways to spend money so they stayed below $2,000. Well, that's not good for anyone. And so the stable account does away with that by creating a mechanism for individuals to save money without losing eligibility for benefits. So I'm not going to read all this to you, but again, we'll make sure this is available to you so you can look through it. It provides some financial independence. It drastically increases the ability of people to save. There are some tax savings and there are tax deductions available for doing this. It's an all-around good tool to use, but you have to understand how it fits into an overall plan. What I like about stable accounts is how it ties together with the overall plan. Contributions, you can put up to $15,000 a year into a stable account. Now, it can be a lot more if you're employed. Over the lifetime of an individual, you can't have more than $462,000, which if you do the math at a maximum of $15,000 a year, it's going to take a lot of years to get up to that amount. They're doing a lot of good things with stable accounts. Here's how I see it fitting into the larger plan, and here's how it does. When we talk about spending money, you have this discretionary trust. In my case, I have this discretionary trust for Megan that's going to have money in it when my wife and I are both gone. And so money's in that discretionary trust, and maybe someday Ruby's going to be the trustee of that trust. Right now, Ruby's 9, so that's hard to picture, but someday when she's much older, maybe she's the trustee of her sister's trust. Well, Ruby doesn't necessarily have to be there for every expense, because like I said, in a perfect world, my wife and I are going to find that perfect independent setting for Megan when she's an adult. And so Megan might not be living with Ruby and probably won't be living with Ruby. So Megan needs that spending money on a regular basis. And maybe it's $20 a week, maybe it's $50 a week. She's going to have her SSI or her employment earnings or whatever else she has, but she might need something extra from the trust. Well, that's where the discretionary trust can be linked to a stable account, and money can be sprinkled from the discretionary trust into the stable account on an as-needed basis. And then once in the stable account, Megan can have a stable card, which is basically a debit card. One of the things I really like about that debit card is when I open the account, I can control how much money that card accesses, or how much access that card has. So if I want to put $2,000 of seed money in the stable account, and Megan is going to the state fair with all of her friends, I can load $100 on the stable card. And so if she gets taken advantage of financially, or somebody steals the card, or if she loses it, then the most they have access to is that $100 I loaded on the card. The card doesn't access the entire account balance. I like that feature. I also like that the treasurer's office, the state treasurer's office, manages these accounts, and they are very good and very accustomed to interacting with individuals with developmental disabilities. And so when you call them for the 14th time in May and say, my daughter just lost her 14th stable card, they don't look at you with judgment. They understand, and they're okay with that. I'm not saying there's not a fee, there is, but they understand that, and they'll work with you. What can the money be spent on? Well, first of all, I do have a chart in here about special needs trust versus stable accounts. Both of these are first-party accounts. And because they're first-party accounts, you should not open a stable account and treat it like you would a 529 plan, which is something I think a lot of parents do because they want to get that tax deduction. What they don't realize is they're putting money into the account, not realizing that when the individual passes away, the money is going to go back to the state of Ohio. And so for that reason, the stable account, we generally advise clients keep that balance low. Keep the balance low, and it should be kind of a money in, money out account. And that's why I use the term sprinkle. When we link it to the discretionary trust, we want the discretionary trust to put money into the stable account really on an as-needed basis. It's a convenient way for us to give an individual access to some of their trust money, but we want to be careful about the amounts. I do, from time to time, have clients that will come in for planning, and it is kind of hard when they tell you, well, we've been putting $15,000 a year in the stable account, and this is our 3rd year now, and it does make me cringe inside, because now they have $45,000 in a stable account, and if the individual passes away, it's all going to go back to the state of Ohio, and that's very challenging, assuming the state of Ohio has spent $45,000 on the individual, but that is often the case. So we've got some more comparisons here. I'll let you guys look through this when we get this information to you. I'm not going to read all this to you, but when you get it, you can certainly look through it, think more about that. How can the money be used? Well, stable accounts, to be quite honest with you, it's confusing. If you look at the statutes, these are examples of the things the stable account can be used for. However, right now, there really is no enforcement or oversight on the use of stable accounts. And so a lot of individuals go far beyond what's listed in this screen for what they use stable accounts to pay for. I used earlier the example of my daughter going to the state fair. Well, is that a basic living expense, going to the state fair? In the context of other types of trust and special needs situations we get into, the answer would be no. In the context of stable accounts, no one at the different regulatory levels of the government seem to care. No one's being audited, no one's being reviewed, and so no one is really getting in any trouble whatsoever for using it on entertainment or things like that. I always worry that someday there'll be a gross case of abuse or misuse, and that'll ruin it for everyone. But right now, there's really not a lot of oversight whatsoever on how people are using these funds. So there's the technical answer, and then there's the practical everyday answer. So again, these are a piece of a larger overall plan. They're not the end all be all of a plan, and it's not something that people should count on stable accounts as an alternative to estate plan. It's part of a larger overall plan. Some of the things that are becoming more and more popular are with certain types of special needs trusts, there are limitations on the ability to pay for shelter. The discretionary trust we talked about is not the case, but with a first party special needs trust, you're not allowed to pay for rent, things like that. Well, a stable account can. And so stable account is actually a broader menu of things it can pay for than some of the different types of trusts. And so for that reason, it's even more advantageous to link it to the trust. I've seen a lot of families using these for graduation gifts. That's become really popular the last couple of years. Is you'll see families where someone with a developmental disability is passing away, and instead of getting checks or cash and then having to sweat about whether or not it's going to interfere with their eligibility for Medicaid, families will have people give gifts to stable accounts, which you are allowed to do. That is an option. Okay, before we move on to the next phase, I want to talk about one more thing that I don't have a slide for right now, and that is Social Security, because I know there's a lot of questions and confusion that comes up with the Social Security benefits. And Social Security is one of the more confusing. But before I go on, hold on one second. I got a question here. More a statement than a question, but a statement I agree with. All right, here's one. So, very good question. Once someone receives money, and once someone receives money through, maybe it's Social Security, maybe it's a lawsuit, something like that, how long do they have before they get in trouble and lose benefits? So how quickly do they have to act to protect their benefits? It depends on what type of asset it is and what they've received. For lawsuits, for inheritance, things like that, they are income in the month they're received, and they're an asset the following month. Now, for Social Security benefits, for SSD, there is a grace period. So if you've switched from SSI to a different type of Social Security, you do have a grace period, depending on the benefit, but generally it's 6 months to do something with that asset before they're going to count it against you. But for other things like the lawsuit example, the inheritance example, you got to act pretty quickly, because it does actually disqualify you as an income source upon receipt, and it can disqualify you as an asset after you hold on to it for too long. Someone just asked, how do you get overpaid with SSI? You really don't with SSI, but you can with SSD. The only way you get overpaid through SSI is if you received payments you weren't eligible for. But with SSD, which is Social Security Disability, through SSD, you could apply in January, not be found eligible until 13 months later. And because you applied in January, they will pay you for all 13 months while your application was pending. But they pay you all that all at once. And so now they're paying you, $25,000, $30,000 all at once. And then it's a countable resource. But that's where, again, because it's Social Security, you have a 6-month grace period. So, all right, very good questions there. Social Security. SSI is supplemental security income. That's what individuals with disabilities are eligible for. It is a means tested benefit. Eligibility for SSI is based on the individual. Now, one thing you need to be aware of is that SSI, the maximum, it changes every year. I think this year it's $780. I could be off a little bit on that. SSI it's tricky in terms of compliance. The financial requirements are the same as Medicaid. and the financial eligibility requirements are the same as Medicaid. However, what a lot of people don't realize is SSI is based on what the individual's done, but the individual at multiple different points in their life may be able to switch to SSD, but that's going to be based on what the parents have done or what a third party has done. And so, for example, if I trip and fall walking down the hallway tomorrow here at work and I become disabled and I start drawing SSDI, Social Security Disability Insurance. That's something I pay into in my paychecks. And so I become disabled. I'm unable to work. I start drawing SSDI. After I start drawing SSDI, Megan, as an adult, she could also draw SSD. And so if she were an adult, she could also draw Social Security Disability. Now, what's nice about that is her payment is going to be linked to my payment. So I pay into Social Security every month or when I get a paycheck. And so what I get back from SSD is based on what I've paid in. And so my benefit is going to be whatever it is. Maybe it's $2,000 a month. Well, as my daughter, Megan would get 50% of my benefit, which is $1,000 a month. And so then she's no longer going to receive SSI. She's going to get SSD. What's extra nice about that is after being on SSD, that then makes her eligible for Medicare. So not Medicaid, but rather Medicare. Now, I'm going to do something that's very dangerous. I'm going to try to do something that's artistic, and I have no artistic ability. The way I like to think about these benefits is you got a box. You got 4 corners to the box. And I have no idea who named these benefits, but I have some choice words I'd like to say to them if I ever meet the people who named all these benefits. And so you have SSI. And then down here, you've got SSD. And then up here, you've got Medicaid. And down here, you've got Medicare. This is the matrix of benefits that we're often dealing in. You've got the Social Security benefits, and you've got Medicaid and Medicare, which are more health care. Most individuals with developmental disabilities live up here in SSI and Medicaid. They might have a Medicaid waiver and SSI. But then something happens to their parents. Maybe their parents become disabled, or maybe the parents pass away, or maybe the parents retire. But when the parents become disabled or retire or pass away, if the individual is not working and they've kept their work requirements within check, that causes them to become eligible for additional SSD benefits based on what the parents have done. And so that means now we're looking at SSD. Once they get SSD, we're also eligible for Medicare, not immediately, but after a waiting period, you're eligible for Medicare. And so then our matrix shifts from being SSI Medicaid, this top line, to being these bottom 3. And if the SSD benefit is not more than $780 a month or is less than that, you could be receiving SSD and SSI. And so you could actually have all 4 corners of the matrix all at once, depending on what's going on in your loved one's life, which is great because, well, not great. My ideal is to have this horseshoe here where it's Medicaid, Medicare, and SSD, because I'd want to get the monthly financial benefit from SSD, healthcare from Medicare, and then the waiver services from Medicaid. I mean, that's the sweet spot you would ideally love to get to. The reason I don't really want to get there is because it means my wife and I have to either become disabled, pass away, or otherwise retire to trigger Megan's eligibility for SSD. So just understand when it comes to Social Security, everybody always talks about SSI, and that is generally where people start when they turn 18. But there are other types of benefits that can become available. All right. Let me check the chat here. I see it blinking at me. So we've got some good questions. One of them, we've got actually about 3 questions here that are alluding to the same thing, which is the interplay between discretionary trusts and looking at expenses, things of that nature. Um, if the questions are this, if the Social Security money is accruing and it's getting to be too much money, can you take that out and put it into his discretionary trust? And the answer to that is absolutely not, because that breaks our first party and third party rule that we've talked about. And so we've got about 3 different questions here, and it's making me worry that maybe I didn't do a good enough job explaining that. The discretionary trust cannot ever have money that belonged to the individual. And so only money that belonged to someone other than the individual can go into the discretionary trust. If it's Social Security money, whether it's SSI or SSD or any other Social Security benefit, if the benefit is received by the person with the developmental disability, it cannot then go into the discretionary trust. It would have to go into a stable account or a first party special needs trust or some other vehicle, most likely the stable account. But you would not want to put that into the discretionary trust. Okay. And there's another couple questions here that I'm going to hit on in a second. So if I don't answer your question, it's not because I'm ignoring you. I'm going to circle back to it. That wraps up kind of the estate planning side of this. Do we have any general questions on that portion? Okay. Well, so here are some of the takeaways from this. Again, if you're not planning ahead and if you're not thinking ahead, your death is going to cause far more hardship than what you intend when you pass away, because it's going to mess up eligibility for benefits. And so you've all, as parents, spent a lifetime protecting your children. Don't make the mistake of letting the protection stop the minute you pass away. You want that protection to continue on even after your grave by setting up the right type of trust, by setting up the right type of plan. We meet clients all the time, and some have estate plans, some don't. When parents have young children and typical children, I always internally think, yeah, you really should have an estate plan. You're taking a lot of risk, because if something happens to you, it's not going to be pretty if you have minor children, because you get into how the guardianship works and all that stuff. It's even worse though when you have a loved one with special needs, because you're really setting them up for having a lot of money spent on attorneys, and the cleanup work in that situation is significantly more expensive than doing it proactively. I realize estate planning is not cheap. It's something that everybody needs, and it's something that everybody's going to get the value out of if they've done it correctly. And so keeping it private, keeping it personal, and keeping it close to you is what's important, and why we encourage everyone to take the steps to do this and to have the right plan in place so that when you do pass away, everything's structured correctly. So what I'm going to do now, what I'm going to attempt to do now, is I'm going to put up a poll. If you have other questions that I haven't answered that you wanted to get answered, please do not hesitate to send them in the chat. Also, a couple of different things. I'm going to put up a poll now. If this works the way I'm told it works, we're going to try to take care of, we're going to try to help you from making the mistake that I often make, which is I always think I really want to do this, and then I blink, and then 6 months goes by and I don't remember to do it. So if we're doing this correctly, then I'm going to put up a poll that asks if you would like us to contact you. I am not a salesman, and this is the part I'm very bad at. But if this is something you would like to meet with and talk more about doing any estate plan, I'm happy to do that. If you click yes and you put your information in the poll, we are the only ones that will see that. So it would not be available to the public. And then you would also, you could also put your information in the chat, because that's also private. Either way is fine with us, but I would encourage all of you, if you do this, when you put your information in, put your phone number in. Again, we're not salesmen. I'll have somebody from my office call you twice. If you don't answer or you blow us off, we're not going to keep chasing you. We're not selling magazines. But this way it takes away the, oh, darn it, of I forgot to do it, or I forgot to follow up on that. So if you'd like that, we'd be happy to help. Otherwise, there are lots of other attorneys that do this as well. And I would encourage you to make sure you get someone who knows what they're doing, because you want to make sure you get it done correctly, as all of you do need this for your loved one. So I'm going to stick around and check the chat. So I'll try to make sure I answer all the questions if there's anything I missed. But otherwise, I really appreciate all of you participating in this, and we really appreciate the Licking County Board setting this up for us and helping with this. Okay. Let me look at the chat here, see if there's anything else I missed. There is, okay, so let's see. There's a question about how much does all this cost? So that's a very good question, and it's a very fair question. We don't charge clients for the initial meeting because we want you to come in. We have a follow-up where we talk through all this and make it more personal to you to figure out what do you need, what do you not need, and then we're able to give you a better quote. We charge everything on a flat fee basis so that you know up front what's the total cost going to be. For an estate plan of this variety, it can cost anywhere from $2,500 to $3,000 to $4,000, depending on what all decisions you guys make and what's going on in your life. But we will certainly have a very upfront conversation with you, so you know what is involved and you know what the total cost is going to be, and you can make informed decisions. Here's another question. Can funds be moved from a special needs trust to a stable account? The answer to that is yes. So a first party special needs trust can distribute money to a stable account that is an appropriate distribution. There's a question that says, I'm confused about the difference between 529 investment versus a stable account. So a 529 plan is a college savings plan where you can set money aside to plan and save for the college expenses associated with a loved one. A stable account is an account where you can move funds out of an individual's name or from an individual's trust into an account where that individual can control, or the person acting on their behalf can control those funds, knowing that the money in that account will not interfere with their eligibility for government benefits. And so it's one of the many tools we use where they can possess and control money without interfering with benefits. There's a question about, looks like from the stable accounts, about the investment options. When you enroll for a stable account, you do that through the treasurer's office. Then when you open that stable account, they're going to have you make elections in terms of how you want that money invested. And it's not that you're sitting there picking stocks, but they do have different levels of risk that you can choose from, the moderate, conservative, aggressive. You're not going to get rich real fast on a stable account ever, but you do have some ability to control what type of investments it's going to be in. Okay, wait, here's another. It sounds like the main reason to choose a pooled trust over discretionary trust is whether or not there are known trustees that can be named or trusted. If a discretionary trust initially established, but then the named trustees pass away, what is suggested? We want to have a backup plan. So again, in my scenario, my daughters are 11, 9, and 7, and I have a discretionary trust. And right now, Aunt Julie's the trustee of that trust. But if life goes the way I want it to, that trust is going to be around for a long time for Megan. And hopefully, by the time I pass away, Ruby and Leah, my younger two daughters, they're significantly older than they are now. And so my trust already has built into it language that, once Ruby or Leah reach the age of 30, if the then serving trustee thinks they're responsible enough, the then serving trustee can have them come on and be co-trustees. And I do that for a variety of reasons, because I'd want them to be that trustee someday. I want it to be Aunt Julie now because my kids are young. But if life goes the way I want it to, I certainly don't want it to be Aunt Julie by the time it's needed. I would much rather it be Leah or Ruby, one of my other two daughters. So, and also what I like about that is it helps us make sure these documents stand the test of time. Because the discretionary trust, again, we understand that it's an investment and it's a process to go through this. And I don't want you to have to come back in a few years and change things around just because your younger kids got older and it's changed who you'd want to have in those designations. Also, though, if the named trustee passes away, there is always a way to replace them. You can, as a last resort, go to court, and a court can replace a trustee. But even better, I like to say in the document how we can go about having a trustee changed or replaced. And so we would do that through giving the then serving trustees the ability to designate a successor if there's no one left. So in my case, in some horrible scenario where Megan's still alive and her sisters are older, but one is gone and Megan's the last living person. And so, maybe her sister Ruby finds out she's got some horrible type of cancer and a short diagnosis or something, then Ruby could find someone and designate someone to take over when Ruby's gone. All right, that looks like I've got everything. If I'm missing something, feel free to send it in the chat. But again, I really appreciate everyone joining us tonight. So I have to stay on. You guys can, if you have more questions, don't hesitate to type them in the chat or otherwise. Oh, and they want me to share at the end that we will post a link to this video on the Licking County Board of Developmental Disabilities Facebook page. So we'll definitely make sure you can get the video and also the slides. I am going to fix that one typo before I send it to them, though. All right. Well, thank you all very much. Have a good evening.